Hot news: Supreme Court will hear Second Amendment case. The New York Times. Washington. The Supreme Court agreed on Tuesday to hear a challenge to a New York City gun ordinance that does not allow people licensed to have guns in their homes to transport the weapons outside the city. The court has not heard a Second Amendment case since 2010. The new case will. The city's ordinance allows residents with so-called premises licenses to take their guns to one of 7 shooting ranges within the city limits. But the ordinance for 3 city residents and the New York State Rifle Pistol Association sued to challenge the law but lost in a federal district court in Manhattan and in the United States Court of Appeals for the Second Circuit. A unanimous 3 in urging the Supreme Court to hear their appeal in the case. New York State Rifle Pistol Association v. City of New York. Only New York City flatly prohibits its residents from removing their lawfully purchased and duly registered handguns from the city limits, even to transport them unloaded, and locked up to second homes at which they are constitutionally entitled to possess them, or to out-of-city shooting ranges, or competitions at which they are constitutionally entitled to hone their safe and effective use, said. That prohibition does not even make sense on its own terms, the brief said. It has the perverse. Lawyers for the city responded that the law was justified by public safety considerations. Before 2000, the police department, the brief said, observed widespread abuses. Firing ranges. Since its decision in the Heller case, the court has said little about the scope of the Second Amendment. In the lower court, last year, dissenting from the court's decision not to hear a Second Amendment case, that the court was abdicating its duty to protect an important constitutional right. As evidenced by our continued inaction in this area, the Second Amendment is a disfavored right in this court. The right to keep and bear arms is apparently this court's constitutional orphan, Justice Thomas wrote. And the lower courts